Um, to my immediate right is Yaron Gottlieb, who is an attorney with expertise in maritime piracy and has done extensive work for Interpol and the United Nations. He has authored numerous scholarly works with a particular focus on the destruction of religious sites and the transition of these sites when regimes fall and preventing extradition of people wanted for political crimes. We've, of course, heard Professor Murphy's background, but most notably for our purposes here, he has served as the special rapporteur on these articles on prevention and punishment of crimes against humanity. He is also currently a professor at George Washington University School of Law. Leila Sadat, who is a professor at Washington University in St. Louis School of Law, has served as a special advisor on crimes against humanity to the International Criminal Court prosecutor, has published scores of books and articles in leading journals, and it was the director of the Crimes Against Humanity Initiative, the project that really led largely to these articles that are for discussion. And finally, Professor Juan Mendez, who is a professor of human rights law in residence at the American University, Washington College of Law, where he is faculty director of the Anti-Torture Initiative. I do want to just mention it's a real honor to be sitting at this rostrum with all the individuals, but in my early start to a legal career, the name Juan Mendez was really just synonymous with fighting against violations of human rights abuses. His list of accolades and honors and positions that he's held are seemingly endless, but one thing in particular, I think, for the young law students here getting off early in your career, something to know about Professor Mendez is that he was a lawyer defending human rights activists in Argentina during the military dictatorship and ended up being subjected to horrible abuses, including torture, being held without trial for well over a year. And so he really doesn't just write and teach about these issues, but he has lived them and lived his beliefs in the bravest way imaginable. So I'm really honored and humbled to be sitting here with you, sir. Well, with that, I just want, because I know we do have some people watching, and so may not have the text in front of them. I'm not going to read all of the articles here, but Article 2, which is the definition of crimes against humanity, bears some emphasis and articulation. So I don't have quite the radio voice that Dean Scharf does, but I'll try and state the definition. For the purpose of the present draft articles, crime against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack: murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity, persecution against any identifiable group or collectively on political, racial, national, ethnic, cultural, religious, gender, or other grounds that are universally recognized as impermissible under international law in connection with any act referred to in this paragraph. Enforced disappearance of persons, the crime of apartheid, and other inhumane acts of a similar character intentionally causing great suffering or serious injury to body or to mental or physical health. So these are the crimes at issue. This is the basis for much of our discussion today. And I guess I want to begin with Sean and sort of maybe building a little on your comments earlier today, just to try and get an understanding what with all of these other regimes that we do have that are preventative, we have an international criminal court statute, why do we really need this convention?
Well, that was a good question that many were asking at the outset of the project, including on the International Law Commission itself, because obviously there's a lot of support out there for the International Criminal Court. There's a feeling that more needs to be done to improve it and work with it and build it up and support it and so on. And part of the issue was, should we divert energy towards a different project at all, or should we stay focused on the ICC? And I think the answer was, and that ultimately carried the day within the commission and hopefully in the broader community, is that we do want to continue to support the ICC. It's an important institution that has an important role in having an international organization, an international criminal court based in The Hague, capable of prosecuting a certain number of individuals. But the reality is it has limited resources, limited capability, and even if it was functioning extraordinarily well, you would not be able to address the wide range of alleged offenders that are out there. And the court itself is built upon the concept of complementarity, that in the first instance, it's desirable to use national legal systems that are able and willing to prosecute individuals using their courts, their laws, and so on. And only when they can't do it or are unwilling to do it should it end up in The Hague. So if you take that complementarity idea seriously, then you should be interested in building up national laws, national jurisdiction in order to go after the bad actors. How do you do that? You do it through a treaty of this kind. As you said, we don't have a treaty on crimes against humanity, so right now there's not a treaty obligation that's requiring states to adopt national laws on crimes against humanity and so on. You could try to read a part of the Rome Statute in the preamble that there's a duty of this kind, but it doesn't appear even within Rome Statute parties to be having the effect of automatically getting states to adopt national laws and exercise national jurisdiction. So the commission thought that we did in fact need a convention of this type that would be focused on national jurisdictions, and that if it was pulled together properly, it would go a long way towards bringing into the regime not just Rome Statute parties, but non-Rome Statute parties, because you don't have to join the Rome Statute in order to be a party to this convention. And moreover, it could ultimately do quite a bit to help support the ICC. You mentioned and read from the definition of crimes against humanity, 95% of the definition that's in the ILC's article is coming straight out of the Rome Statute. And so part of the reason for that was to try to create as much synergy as possible, develop national laws that mimic the Rome Statute to a very large extent, and that way then we would be supporting this idea of complementarity.
Okay. Does anyone on the panel have anything to add to that about the need for the convention?
So listening to Sean, I think about how far this project has come, actually, Avi, and there's somebody missing from the table, and that's Sharif Bassiouni. Sharif was my mentor. He was Michael's mentor. I was so grateful that Michael Kelly mentioned Ved, who fortunately is still with us. Sharif, unfortunately, is not. But he wrote about this in the 1990s, about how we were missing this part of the infrastructure of international criminal law. And we didn't really think much about it at the time because we were focusing on creating the Rome Statute and getting the International Criminal Court up and running. And really, had we not had those twin things happening, people starting to just think about this missing piece of international law, and at the same time doing the hard work during the Rome negotiations to actually get a definition of crimes against humanity in a multilateral treaty for the first time, right, since Nuremberg, which was astonishing. I think we wouldn't have been able, when I took this over in 2008, to start the Crimes Against Humanity initiative. We were still facing, even with Sharif's work and the Rome Statute, we were still facing a lot of skepticism. Why do we need this? We have the Rome Statute. It could, worse yet, be an American attack on the ICC, being from the United States. And I think what's great to hear Sean speak now today, everybody's like, oh, of course, yeah, what a great idea. But when we first started, really, I had my little PowerPoint, and I would give it to people, and here are the 25 things a new treaty could do. What I would say is one of the key things is the Rome Statute is a vertical mechanism, right? And the difficulty that some states have with the ICC is the addition of the court part of it. This is a horizontal mechanism. This is about empowering states to cooperate with each other for the prevention and the punishment of crimes against humanity, and we don't have that. And the other thing that I think gave a real fuel to our fire and to this project was Bosnia versus Serbia itself. The decision of the International Court of Justice that Sean referred to in his keynote was deeply disappointing in some ways, at least to some of us, because what the court said is, look, we just don't have jurisdiction over much of this because, yes, it's crimes against humanity, but we only have jurisdiction because it was referred to us under the Genocide Convention. And so the only thing we can talk about as a court is genocide. We can't talk about everything else that happened, even though these were probably crimes against humanity. So when you think about that, and I just add one more tiny point, at the ICC, 30% of the cases are crimes against humanity only cases. That is not true of any of the other crimes. Genocide is not useful as a tool of international criminal suppression. It's a useful rhetorical device, but it is not useful as a tool of criminal suppression. Crimes against humanity does a huge amount of work for us at the international level, and the idea is to empower states to now do that work at the national level. And so it's a critical part of the infrastructure.
Juan, do you want to add to that in terms of the need for the convention?
No, only to agree wholeheartedly, of course, that it is important to fill the gap. I mean, we have a genocide convention and we have the Geneva Conventions, so genocide and war crimes are well covered both as criminal statutes and international criminal statutes and as normative framework for state responsibility. But on crimes against humanity, we needed to fill the infrastructure, as Leila said. And I want to say that I was very honored and proud to be invited by Leila to participate in that early exercise with masters like Sharif Bassiouni and several others. And I think, in fact, it is great that the definitions, we haven't really gotten into that yet, but the definitions track as much as possible the Rome Statute, mostly because the Rome Statute, when it was drafted, reflected a very broad, very complete consensus in the international community about what were crimes against humanity. We had been talking about crimes against humanity since Nuremberg, and perhaps even a little earlier, and yet until 1998 we didn't really know exactly what we meant by it or what kind of actions constituted crimes against humanity. And I think this draft really does well in following the Rome Statute, although in some aspects it departs positively towards more modern definitions.
Yaron, how about you? Anything to add?
Thank you. Good afternoon. An opportunity to thank Dean Scharf and his team for organizing the event, for inviting me to participate and contribute to the discussion. Very briefly, I will join those commending the efforts on this draft convention. By all means, it's a welcome initiative. And in particular, the attempts to create a platform for international cooperation, as mentioned by Professor Sadat, on the horizontal level, specifically provisions such as extradition, MLA that can serve as a legal basis for international cooperation, which is something that is often lacking on the international level. So in that regard, very much a welcome initiative. Commentary beyond that on Article 2 of the Convention, and I'm glad that you started with a quote. I think we can leave to the second round of discussion.
Yes, absolutely. So I want to focus or drill down a little bit more on the particularly positive aspects of the articles. And perhaps, Leila, you could begin. And we were originally going to have one more participant. Charles Jallo was going to join us, and for, unfortunately, some logistical reasons, was not able to. So Leila is going to speak also on his behalf. I think maybe they share some similar views on some of these, but please.
Well, although perhaps not as eloquently, Charles is always wonderful at making his point. So I think one of the things that Charles had been tasked with speaking to, and that I'll just echo, is that the International Law Commission, like our initiative, took the Rome Statute, Article 7, as the centerpiece of the new treaty. And that was critically important because you don't want to create incoherence in two regimes. ICC statute already has 124/23 states and 165 states. As Professor Mendez said, we had a huge negotiation in Rome, and we finally got a codification of that. So taking as the centerpiece of a new Crimes Against Humanity treaty for our project and for the International Law Commission, I think it was centrally important that it be the Rome Statute definition. We did not vary it at all. What has happened with the ILC is the ILC has deleted subparagraph 3 from the Rome Statute, which was bothersome to many. It had this definition of gender that was objectionable to many, and the ILC, and I think the commentary is beautifully written, sort of makes the case for why that is both anachronistic and should be removed from the new draft treaty. And the other element, which I'll talk about later, which I don't like, is changing the definition of persecution. But we can come back to that. The other really positive thing I think that's wonderful is the prevention pillar that the International Law Commission picked up and really ran with. And there's a wonderful section on prevention now in the ILC draft. Liability for legal persons. Finally, we get that in a treaty, which I think is a very important advance. You know, one of the things that was the comment made to me often in my advocacy for this is, well, what new is going to be in this? Why should we go through all the work? Well, there's some real innovations here. Another one that I think is very important is the mutual legal assistance provisions are really well developed in this new draft. We took the views that since this was a modern treaty, it should have modern interstate cooperation provisions on it. And so our model in our version, which is up on the internet, is basically to take the UN Convention on Organized Crime and on Corruption and the modern sort of transnational crime treaties that have very, very effective interstate cooperation provisions and marry them, in a sense, to the Jus Cogens norm. And the ILC has basically taken the same view, not identically, but I think it's done a really, really nice job. And finally, the other thing that I think is going to be a model in the future is Article 10 of the ILC draft articles, the aut vedere, aut judicare, with the triple option is excellent. It allows not only for the national jurisdiction to try, but for surrender or extradition to a, quote, competent international criminal court or tribunal, as well as another state. And so I think that's a modern and really advantageous provision, and thank the Commission for that excellent drafting.
Juan, do you want to add to that?
Yeah, thank you. What I really like about the draft articles is that although the point of departure are the definitions in the Rome Statute, they also reflect to a very significant extent, although with some caveats to be explained later, jurisprudential and normative developments that have happened since 1945 and even since 1998. And I think to that extent, it's just not a cut and paste job of the Rome Statute. And I'm particularly happy with, for example, the specific norm that says that statutes of limitations are inapplicable to crimes against humanity, because that has been, at least in my region of the world, Latin America, a point of contention that fortunately has been moving forward in the positive direction, but there are still jurists and courts that resist the inapplicability of statutes of limitations to crimes against humanity. I also thought it was great in the preamble to change the word recognizes to recall, to reflect the fact that crimes against humanity have been part of customary international law for some time now, and so the ratification of by any given state by of the eventual Convention on Crimes Against Humanity will not signal a cutoff date backwards from which you cannot go. For example, one of the main problems in the Supreme Court of Uruguay with implementing a decision called Hellman versus Uruguay by the Inter-American Court on Human Rights is the Supreme Court of Uruguay says crimes against humanity have not been part of our domestic law until such and such a date. I think is a ratification of the Rome Statute. I think this sense that in this regard and in many parts of the draft articles, this is declaratory of custom rather than creating new treaty standards, I think is important. And also in that same line, I am really happy to see specific norms about command responsibility and the no obedience to orders as a defense. These, of course, are in the Rome Statute, but it's important to put them in a state responsibility kind of treaty like this one will eventually be.
Yaron, you want to add?
Thank you. Very briefly, I think the strength of the current draft as we see it is a combination of notions introduced from modern treaties. The Palermo Convention was mentioned, the Rome Statute, for example, in reference to reparations and the role of victims. So we see it today, it's evident. 20 years ago it was not. And then at some point in time, in some provision, moving forward beyond that, such as on legal person, and in particular, I think the preventative angle here is important, and I will get back to it later on.
Well, thank you. So it's of course very easy to praise the document with the special rapporteur here, right here on the rostrum. But I guess I would now, ask you all to express what you take issue with in this document, and perhaps then Sean can respond to some of these criticisms. Obviously, he's quite comfortable doing so. He's dealt with plenty of commentators or commentaries and has provided them all to us. So I don't know if Juan, you want to take the first whack.
Yeah, by all means. But I have to, a disclaimer that I completely agree. Like we say in Spanish, sometimes the best is enemy of the good. And I completely agree that we have to have a balance between what we would like as a utopia, as Michael said this morning, and what we can really get away with. No, I mean, can really achieve. And as long as what we can really achieve, it really pushes us forward in the fight against injustice and mass atrocities. In that sense, I mean, I would like to see something like the reference in the Genocide Convention and in the Rome Statute with regards to genocide on direct and public incitement to commit genocide. I am a great supporter of freedom of expression, and this morning we had a really good discussion about that. And I'm not talking about hate speech. I'm talking about direct and public incitement to commit crimes against humanity, which is a much higher, much stringent category than hate speech. I think it would be good at least to contemplate possibly that, because as Antonio Cassese said, there is no hierarchy between genocide and crimes against humanity and war crimes. They're all in the same category in the sense of requiring from the international community some response, and therefore this standard of direct and public incitement would be important to have. I also like very much the very clear standard of an obligation to investigate, prosecute, and punish. So the affirmative obligation is clearly there. But I would like to see some reference to the prohibition of amnesties that have the legal effect of not permitting investigation, prosecution, and punishment of the crimes against humanity. Maybe it's because in my part of the world, this has been the hardest legal battle fought. I know in many parts of the world, impunity has different faces, and sometimes it's just de facto impunity. We had a lot of that in Latin America also, but we also had de jure impunity with self-amnesties, amnesties almost literally extracted at the point of a gun from democratic governments, pseudo-amnesties with other names, etc. So to a large extent, we have won that battle in Latin America, not everywhere, but in many places, and we have very strong jurisprudential contributions by the Inter-American Court on Human Rights, unmistakably saying that amnesties that have the effect of not allowing the investigation, prosecution, and punishment of crimes against humanity are contrary to international human rights obligations of the state. I would like to see that, but I am I'd settle for the affirmative obligation without reference to the prohibition on amnesties, but at least from our experience in Latin America, it would be great to have that. I have a few other comments, but I'll let others say their comments.
Sure. Maybe we'll let the criticisms go forward, and then we'll see how Sean responds. Yaron, do you any particular you want to share?
Thank you. And I would like to go back to Article 2, which is the heart of the discussion, in my view. And from the outset, as was mentioned here, the focus was on the other provision of the convention and relying practically exclusively on the Rome Statute, the Rome Consensus from 25 years ago. And then by doing that, really enabling the negotiations to focus on the other parts of the convention. And certainly there's value in that, advantages to this methodology. We always have to bear in mind this need to reconcile between utopia and reality. And I'm a practitioner, so I'm aware of political compromises, etc. And yet, I think this is an opportunity to look back 25 years back into the 1990s and to ask ourselves a question. Has anything changed since then? Isn't it time to take stock and to say, look at what has happened since the time the Rome Statute was negotiated, similarly to what was done in the 1990s, going back to Nuremberg era, and maybe to conclude it's time to recognize other crimes against humanity that are out there somewhere. And interestingly, when we look at the draft convention, we find it in Article 2, Paragraph 3 of the draft convention that states that this draft article is without prejudice to any broader definition provided for in any international instrument, in customary international law, or in national law. So setting aside national law, there is recognition here that there might be, as of today, not only in the future, but as of today, there might be other crimes already out there somewhere in an international convention, customary international law. And I believe the exercise of discussing it and concluding whether indeed there is something new, or alternatively, whether we are content with what took place in the 1990s, I think it has merits. And I think we want to avoid a situation where 20 years from now, we'll have a conference here in Case Western, and looking back, we would say, why didn't we include it at the time? It is not impossible to amend a convention, but it's rather difficult. It's best to do it in advance to the extent possible. One counter-argument that was raised against such a thorough study and thorough discussion was the fragmentation that we might be creating on international law if we have a draft convention, or eventually a convention, which differs on the substantive law from the Rome Statute. And of course, this is a valid concern as well. But as we look at the Rome Statute, Article 10 specifically states that it is not aimed at preventing the development of international law. And if indeed in the context of a study of the current framework of crimes against humanity, we conclude that there are other crimes that are worth taking into consideration and included in the convention, then maybe we can go back to the Assembly of State Parties of the Rome Statute and integrate it in the Rome Statute rather than simply say we are content with what we have in place. And so I think the Rome Statute should serve as a benchmark for negotiation rather than to view it as ultimate text that we simply borrow it as such and move on to discussion only the other provisions.
Thank you, Yaron. Leila?
Yaron's point really evokes sort of one of the things we struggled with at the very beginning of this project, right back in 2008, was dealing with skepticism about whether there should be a new treaty at all. I mean, and so other crimes that were evoked at Rome, economic blockades, and a crime that's often discussed today is grand corruption, right? As a crime that, that could be a crime against humanity. And so I think what we concluded was we couldn't see to expanding, but I think it's a fair point. And I think that this leads to sort of my small critique of the excellent work of the International Law Commission, which is, as Juan said, this is a document that is steeped in customary international law. And there's a slightly positivist bent to some of the commentary, especially. I would have loved, Sean's heard this before, it's not news, I would have loved the Martins Clause. It seems strange to me to have a new Convention on Crimes Against Humanity without a Martens Clause. After all, the Martens Clause, which is the provision in the 1899 and the 1907 Hague Conventions that says until a more complete code of the laws of war, the inhabitants remain under the protection of the laws of humanity and civilization, right? That preambular paragraph that actually gave rise to the crimes against humanity prosecutions at Nuremberg, it seems odd to me not to give a nod to that. I understand that states get scared by crimes against humanity because it is often a state crime, and states are worried about that, which is probably why we've never had a crimes against humanity convention before. So I understand, as my colleagues do, this, the best can't be the enemy of the good, or whatever. But I think not having a Martens Clause and not having that express acknowledgement that there is stuff outside the four corners of this treaty that could be a crime against humanity. Now, the International Law Commission did include a paragraph in the definition that sort of does this, that it doesn't do quite the same thing, but in Article 2, Paragraph 3, they say this is without prejudice to a broader definition provided in other international instruments, right? But then there's a small sentence buried in the commentary that says, but of course, if you do any of that in your national law, you can't use the provisions of this convention for interstate cooperation. And I think that is too positivistic. I think that's actually not how international criminal law works. Spain modified the definition of genocide, and we still had extradition and European arrest warrants on genocide cases in Europe between countries that didn't have that definition. So I think for me, just leaving that space for development is really important, because the benefit of codification is the benefit of codification, and the downside of codification is the exclusion of other things. And I think a little more space, which maybe wasn't the ILC's job, frankly, it may be the job of states going into negotiations. The other thing I would have loved to see, again, Sean won't be surprised by this, he's received my written comments patiently at many occasions, is the lack of a monitoring mechanism. We have monitoring mechanisms for so many things. How can we not have them for crimes against humanity? The argument, of course, is we already have too many monitoring mechanisms, we just don't want to add one. The Committee on Enforced Disappearance, of course, says, no, we don't need something on crimes against humanity. That strikes me as slightly spurious in the sense that crimes against humanity is the larger, right, of the categories. And it could be something combined, like crimes against humanity and genocide, or there could be some creative way. See, they've blown me, right? They're mad at me. The other thing that I think will come around probably if this goes to negotiation, and we hope it will, and certainly the excellent work of the International Law Commission suggests that it will, is probably a no reservations clause and a strong dispute settlement mechanism that allows for jurisdiction in the International Court of Justice. And an opt-out might be okay from that. As Sean and I have talked about, because states are less likely to opt out if they have to do it affirmatively, but then it has to be combined with the no reservations provision as well. So states can't sort of pick and choose which parts of the treaty they do and do not ratify. And finally, I'm sorry to go on, but I'm trying to be Charles too, is the definition of persecution. The ILC, apparently it was a typo in one of the earlier drafts that I saw, had actually deleted the entire sentence in Article 2(1)(h), where it says, in connection with any act referred to in this paragraph. So the ICC statute refers to genocide, war crimes, and crimes against humanity, and presumably one day that would be aggression as well. The ILC has removed the crimes, but just says any act in this paragraph. So what that has the effect of is to narrow the definition in the ILC draft beyond the narrowing already extant in the Rome statute, because you've removed the possibility of war crimes being a predicate to the commission of persecution as a crime against humanity. Is that just hypothetical? No. Think of Mali, destruction of the shrines, and Timbuktu could be the link that you then use to show persecution as a crime against humanity. So that is one where I just like to strike the entire in connection with language. That is a Rome Statute innovation. It's not present in other international criminal law customary instruments or jurisprudence, and I think that would be one that I personally would like to see come out. That said, those are in a way nitpicks to what is otherwise a very fine document.
All right, thank you. So, Sean, I can recount the critiques, or I don't know if you want to.
No, I'm
down there. You can you can take them.
I definitely like the segment when we were saying all the good things we liked about the articles. No,
We've come to praise you, not to bury you.
I very much joke in that regard. I think that now is the perfect opportunity to be raising these issues about possible improvements, and I say that, and I'll just remind folks in case it wasn't obvious. What's happening right now is the commission has completed its work on the articles. It's being sent to New York. It has been sent to New York. And by the way, if you want to see the full set of draft articles with the full set of commentary, all you need to do is Google International Law Commission. Up pops the homepage, and on that homepage is the 2019 annual report. You click on that, and it's Chapter 4 of the 2019 annual report. So you'll see the full set of draft articles, the full set of commentary that's now been sent to New York. That will be debated at the end of October by governments in the 6th Committee of the General Assembly. And then sometime in the November timeframe, there will be a dedicated resolution by the General Assembly about what to do with these draft articles. If all goes well, the decision would be, let's move forward either right now with a negotiation, diplomatic negotiation, or let's give ourselves 12 months to think about this and then move forward with it. In either event, the story's not over yet, right? These articles can be changed, can be improved. All of the conversation that's happening here and other thoughts that people have can very much be fed into the equation. So this is all wonderful in that respect. And I do also want to say that as the commission was doing its work, we benefited hugely from Washington University's work in trying to develop this idea, which included its own draft of a convention that was sort of the first time somebody had tried to put it all together. That's been helpful, and we also, since the ILC launched the project, have been organizing workshops around the world to get this exact kind of feedback. Again, Washington University instrumental in funding a number of those workshops. So at Nuremberg, Singapore, Peru, I'm not sure where else, London. We've had them in a number of places. Harvard this past January, that have been extraordinarily helpful in making the product better, and I'm sure that more can be done. So let me just touch on a few of the issues. Yes, we track the Rome Statute very closely. We did that initially to deflect some of the concerns that this might be an attack on the Rome Statute in some way. And because of a concern that we might be reopening some of the debates that existed in 1998 and sort of got settled. Not everybody was happy, and that a lot of this would come crashing back around if we once again tried to reopen things. So we tried to avoid that, although, as Layla said, in the second draft, we did make a significant change, which was to delete the definition of gender, because it wasn't coming from the ILC, because we got a lot of comments from governments, from special procedure mandate holders, from NGOs saying, you've either got to delete this or change it. And that gave us, what we felt was a basis for doing that.
Could you actually speak to what that older definition was, just
Sure.
for those who may not be aware?
So it actually does relate to the persecution element because the persecution clause, Article 2.1h that you read, Avi, says persecution against any identifiable group, and then it lists a number of things, including gender. Now, the Rome Statute did not define any of those terms except gender. So it doesn't define racial, it doesn't define national, it doesn't define ethnic. For some reason, it felt it had to define gender. It defined gender as meaning, in this context, the difference between a man and a woman. That's a biological concept of gender. The sense today is that when we speak about gender, it is often talked about more as a sociological concept, not a biologically driven concept, but sociological, how one defines oneself. So what we did was, and that was the controversy, we pointed to a number of precedents since 1998 that have gone in that direction of recognizing the sociological basis. And then we knocked it out of the Rome Statute. Now, we didn't replace it. So what we've effectively done is left to states to use the concept of gender as it currently operates in their national legal systems, and that will differ by states. We could have tried to do our own definition. That would have run into some issues on one side or the other, but it basically puts that term in the same category as all the other terms. We haven't tried to define it. It'll operate within the national legal systems as it does already in their national criminal law. The incitement issue has come up with some regularity, and it relates to the panel we had on social media, so maybe I'll say just a word about that. We did not include the word incitement in the list of what you might call secondary forms of liability. So we do have the terms ordering, soliciting, inducing, aiding, abetting, or otherwise assisting in or contributing to the commission of the crime or attempted commission of the crime. Those terms come out of the Rome Statute. So the Rome Statute has each of those types of terms. The Rome Statute does not include the term incitement in the context of crimes against humanity. It does include it in the context of genocide, probably because it is in the Genocide Convention, but it doesn't relate it to crimes against humanity, and it doesn't relate it to war crimes or aggression. So we basically, again, were just following the Rome Statute approach. Now, if you read the commentary, what you see is that in the Commission's view, incitement is not included as an inchoate crime, meaning that if the crime against humanity never occurs, then you can't be prosecuted for what someone might consider to be incitement. But in the Commission's view, these various terms that I read out would cover incitement when the crime is committed. So part of the question is it important to have that particular word, incitement, in? And a conversation about that should probably talk about, is that word used in other languages? It's clearly used in English. You want to think about French, Spanish, Chinese, Russian, Arabic. These draft articles are in all 6 languages, right? So one question is, how does that particular word work in the other languages? And then the other question is, substantively, what are you looking for? If you're looking for the possibility of getting somebody for inciting a crime that happens, at least in the Commission's view, it's already in the document. Just a couple other things. Juan's absolutely right. We have not prohibited amnesties in these articles. I would note, though, that we have also not authorized amnesties. We're silent on that issue, but the commentary does point out that there's an obligation to adopt national laws to criminalize these acts. There's an obligation to prosecute or submit to prosecution any alleged offender of the act that turns up in your territory unless you extradite. And so you put together a lot of these provisions, and the commentary says, in context, the question is left open, what does this mean for amnesties? I think it's going a certain distance and saying this is not such a great thing, right? And that's kind of where we ended up on that particular thing. Last thought, Layla is absolutely right that there's sort of a positivist bent to this. That's that, I don't know, middle of the spectrum. We don't want to be so weak that this doesn't do anything, but if we get too far ahead of ourselves, it's not going to sing either. This links in part to the issue of the monitoring mechanism, right? It's clearly not the case that you can say customary international law requires a monitoring mechanism. I mean, maybe you could try to argue that, but it's an interestingly difficult argument, I think. That's clearly a construct that must be something that states come together to do. And so the Commission's position wasn't that it was a bad idea. The Commission's position was, in fact, we analyzed the different possibilities for a monitoring mechanism and some of the advantages and disadvantages, but basically we've said we leave that to the states to decide. There's going to be resource implications. There's going to be questions of overlap with existing treaty monitoring bodies that do already deal with some aspects of this. You know, the Torture Committee is going to deal with not just one-off torture, but torture in the form of crimes against humanity, right? So there's some overlap there, and it's also possible, as Layla suggested, to think about genocide and crimes against humanity as some kind of a mechanism that would overlook both of those treaties. We felt that was outside the scope of our mandate. So we left certain things to states. That includes the question of should there be reservations or not. And that's why I say the story will continue from here forward. None of these ideas are off the table.
So moving on then, not so distinct, but a little bit of how perhaps some of the panelists might improve on the convention. I wonder if Yaron, you might begin. I know you've focused a lot on cultural heritage sites and perhaps how that intersects with crimes against humanity.
Yeah, thank you, Avi. So moving from the general to the specific with the timeframes that we have, I have also a concrete proposal to the extent that Article 2 would indeed be open for negotiation and discussion and consideration would be given to including new crimes. My concrete proposal was to introduce a new crime against humanity, specifically on widespread or systematic attacks against cultural heritage. And this might sound at first as a revolutionary a new idea, but in fact, when we look at it more closely, it's not necessarily the case. In fact, it's a proposal I made already 15 years ago with a proposal to amend the Rome Statute with new war crimes and also a crime against humanity, specifically on that area. And what we've seen in the past 20, 15 years, we have felt my own humble conviction that it's timely to rediscuss this. And very briefly, to go over the reasoning behind this proposal. Destruction of cultural heritage has been recognized for many years as a serious violation of international law by ICTY, wealth of jurisprudence, more recently by the ICC in the Ahmadi case, and it is also considered a serious violation of customary international law. So the first concern that we might hear about reopening the Article 2 and introducing new crimes, namely that we would find ourselves departing from what we consider core crimes, is less evident here because of the serious violation of customary international law, again already widely recognized. Now a question might arise, and in such a case, why do we need new crime? Maybe there's sufficient coverage under international law. And the answer is that's not exactly the case. And in fact, the reason for my proposal is threefold. First, existing international criminal law does not provide full coverage. Consider, for example, a situation where we see large-scale, widespread attacks, destruction of cultural heritage during peacetime, and without a discriminatory intent, without targeting an identifiable group as such. In such a case, we don't have the crime of persecution. And interestingly, and unsurprisingly, unfortunately, the three large-scale campaign of what we call iconoclasm, namely the destruction of relics, of cultural relics, religious relics for the message they allegedly convey. And we've seen it in Mali recently, we've seen it in Syria and Iraq by Daesh, and previously, of course, in Afghanistan by the Taliban. In all three cases, it would be very difficult to identify any intention from the offender side to target a particular group. In fact, they target the heritage as such, and no less interesting, they target the international community values. This is what it's all about. It's about the message they convey with the destruction, hence the link to crimes against humanity. Secondly, beyond the legal gap, following such acts of destruction that we've seen in the past 20 years, we've heard numerous statements, international organizations, countries, civil society, and that's something common, and that's the terminologies they used. For example, these acts of destruction shocks the conscience of humankind, or the impact on the international community as a whole. Sounds familiar? Yes, this is precisely the discourse of crimes against humanity. That's precisely the terminology that we use when we speak about crimes against humanity. Here again, because the international community as such is targeted. But the law has been lagging behind the rhetoric, and I think it's time to align the law with the rhetoric. And in that regard, going back to what Sean mentioned earlier today, the stigmatization of the act itself and the expressive value of introducing this new crime in the context of an important convention such as this Convention on Crimes Against Humanity, and specifically, again, to counter the message coming from these terrorist groups. They want to destroy, we want to build. They defy our challenge, our core values as international community. We want to suggest differently and to express how we cherish these values. We spoke about the preventative angle of the convention, very important. In the context of cultural heritage, particularly important, because oftentimes cultural heritage that was destroyed cannot be reconstructed. It's irreversible. The Bamiyan Buddhas destroyed 20 years ago are still there. It would be impossible to reconstruct them again, hence the importance of prevention. Last but not least, and again, there's much more, of course, for discussion, and also in my written submission, I spoke earlier on about the importance of looking back 20, 25 years and seeing and appreciating the developments and assessing them on the international level. At least two worth mentioning here. In the Al-Mahdi case, ICC, for the first time ever, an international court recognized the international community as a victim of a crime as such in the reparation order, specifically about cultural heritage. Second, we spoke earlier about the Security Council and, of course, the challenges that we've seen on Security Council level. But also, one good change, a positive change that we have seen is the broadening of the scope of what constitutes threat to international peace and security. In the 1990s, when the Rome Statute was negotiated, the link between destruction of cultural heritage and threat to international peace and security was considered rather tenuous, quite remote. It's no longer the case. In the past 15 years, we've seen a series of Security Council resolutions, most of them Chapter 7 resolution, recognizing, acknowledging the greatness and seriousness in relation to destruction of cultural heritage, mandating peacekeeping operation to protect cultural heritage, for example, in Mali. So this link by now is firmly established. So the combination of this reasoning, and again, there's more to discuss, lead me to the proposal to consider this in the context of negotiation.
Thank you, Yaron. Juan, some improvements perhaps.
Yeah. Well, at the risk of increasing my wish list for what this, and again repeating that I completely agree with Sean that it's best to have a very good convention than one that has everything but has very little chance of being ratified or even ever seeing, ever becoming, seeing its entry into force. But in one way in which they're tracking the definitions of the Rome Statute is not completely satisfactory is in the definition of disappearances, because there has been normative improvements after 1998, and particularly the articles and the Rome Statute have a couple of requirements that maybe for the jurisdiction of the ICC are valid, and that is the specific intent to deprive a person of the protections of the law, and also that the disappearances has to be for a prolonged time. I would really like to track the UN Convention on Disappearances on that does not have either of those two elements. And this has very good practical results because, maybe we don't have now disappearances with concentration and extermination camps and decades later the family doesn't even know the fate and whereabouts of a disappeared. But we certainly have a lot of temporary disappearances. That is, not just the extension of beyond the 24, 48 hours in which you have to bring somebody before a judge. I mean temporary disappearances of several weeks. For example, the extraordinary renditions is an example of that. And so the danger that we might not outlaw this practice, even if in the end the fate is not the killing of the person, but some kind of recirculation into the prison system or even the release. I think we need to have a convention that outlaws temporary disappearances, however defined, and at least not one that restricts the definition of disappearances to only permanent ones. My other point would be no reference here to military courts. And again, the experience, certainly in Latin America, but I think in many other places, is that military court jurisdiction can be the black hole in which all of these cases go into, and then they're covered by impunity. Now, I understand that if we are applying international humanitarian law, then obviously military courts have a role to play. And I'm not saying that military courts everywhere and always are a pretext for impunity, but they are frequently enough that at least for those cases in which crimes against humanity happen outside the area of armed conflict, there should be a specific prohibition on using military courts because they become a personal privilege and not a functional court. Sorry to take too much time.
No, not at all. Leila, I'm going to let you have the last proposal.
So we are more than 75 years after Nuremberg. And if you remember, one of the 3 crimes for which the Nazis were prosecuted at Nuremberg was crimes against humanity. We don't yet have a comprehensive specialized convention on crimes against humanity, but we're really close, right? I feel like I already got my Christmas present, Sean. This is fantastic. We can all find things, and Sean has received many letters from me detailing all sorts of details that could be, tweaks and improvements, but we are really, really close. And so what I think I'd rather leave people with, rather than discussing this particular effort, you have my written remarks are outside. We actually made a film about this, why the world needs a new Crimes Against Humanity Convention. I have a few copies. Sean appears in the movie, as does Sharif Bassiouni, by the way, because we had him on film. What I really want to leave you with is we're this close to actually doing something positive. Like David Crane, I want to sprinkle a little optimism into the room here. The states now, the last count, we keep count, it's all on our website. The last time that this went to the 6th committee, of the 55 comments, there were only 4 negative comments from states: Sudan, Iran, India, and China. Maybe not so surprisingly. I was awake the night before they sent this to the drafting committee thinking something's going to happen at the last minute. It's just, who knows, Mr. Juan or somebody's going to come in with a statement and it's all going to fall apart, and it hasn't. So really, I just want to thank the International Law Commission. It's a miracle that we are where we are, given the state of world affairs today. And so what I'd really ask you all to do is learn about this, educate yourself, advocate for this. This is one small step forward, right, to making that dream of never again a reality. And that's an important dream to hold on to in these kind of tough times of states. So I think I'll just leave it there. And thank you for an early Christmas present.
All right. Thank you so much, panelists. Now it's an opportunity for folks to ask a few questions. So I'd love to take a few. Right there. Thank you.
Thank you very much. And thanks for a terrific panel. I don't know if anyone remembers, but I spoke at ASIL many years ago about this convention when I was the president of the state parties to the ICC. When it was, I think you were there, Leila, and you hated me.
I did.
No, just to say, because you talked very extensively about the definition. I said at the time, this is a great project in principle, but I'm concerned about the discussions on the definition. And everybody said, unanimously we're not going to touch anything in the definition of Article 7 of the Rome Statute because we know it's dangerous. Now the ILC has touched it, and I do understand that. But I think it foreshadows Sean said, and I think it honors you, Sean, that he said, this can be changed and can be improved. But I represent the government, so I know this can also get worse when we touch it. And the discussions on Article 7, I think, will be difficult. The reason why the definition of gender was in is not because states like us wanted it, but it is because states who did not want certain provisions in Article 7 would otherwise not have agreed to Article 7 as a whole. So to take that out is certainly fine with us. It won't be fine with others. And I think the only way that we can approach that is to say, well, we don't actually need a definition. We know what gender is, which is what we said in Rome. But I'm afraid we may have a similar discussion, and I don't think it will be easier, honestly. I don't want to take too long. I think the amnesties issues will be big for a number of governments, from Juan's region and from others. I don't fully agree that saying you have an obligation to investigate and prosecute takes away the argument that you have to outlaw amnesties, because you can have both at the same time. And we don't have a position on this, but we will probably say that. Then and no reservations, I think, is a no-brainer from my perspective. If you can say, I exempt myself from Article 7, but I ratify this, it's pointless. And it will be difficult to get that in. Just on new crimes, and I think that will be a part of a very difficult discussion. And you came close to that, but didn't say it. But what about environmental crimes? I think that is the very obvious thing that people will say. And, you have essentially talked about, destruction of common heritage of mankind. If anything, it's our common planet. So I don't know if anyone's going to say that. I would be very surprised if no one said it. And you can imagine how easy that discussion will be. So, I look forward to this. This is very exciting. And I don't want to be pessimistic, but it may be a different Christmas that you actually get this, Leila, not this year. Thank you.
Michael? Right down.
Well, like Christian alluded to, 10 years ago, Leila was the salmon swimming upstream. But now, a lot of the fish are swimming behind you. And I guess my question for you is, what lessons or what takeaways have you come out of this process with from the perspective of being in the thick of the politics of international lawmaking?
Well, I'm going to quote Ben Ferenz, who, by the way, his wife just passed away. Never give up, never give up, never give up. I think that when you have an idea, the other thing I would say is always collaborate with people. It's always a team effort. We had a steering committee. Juan's a member. Sharif was our principal architect of our draft. Christine, others. You really have to have a team, and you're just not going to be able to do this alone. And just work with other people and play nice and be persistent. I think that's really the thing, is just be persistent. The other thing I would say is the new social, we made a movie, we made a film, we had PowerPoint, we tried to do some advocacy around this issue. It was an obvious issue to those of us working in the field, and it was really not obvious to anybody else. When we would go and do our presentations and say, hey, how about a new convention on crimes against humanity? People would say, we don't need that. We have the Rome Statute. We'd but the Rome Statute doesn't do this. And so it actually became a question of making the case. And the only other takeaway is that even though it's frustrating that it's taken a long time, time is necessary because when you're doing things on a global effort, you have to get a lot of different people involved. As Sean said, we did a conference in Latin America. We did another one in Singapore, in Europe. I've done a couple events in Africa. We haven't done as much outreach to Africa and the Middle East, but it's a really big planet and people have different perspectives. So that has to be listened to and taken account of. Yeah, thank you.
So, Leila, you mentioned that 60–70% of crimes prosecuted at the ICC are actually crimes against humanity as opposed to genocide. And at the same time, there's sometimes this perception out there that genocide is somehow a lot more important as a crime, a lot more serious as a crime than a crime against humanity. So to what extent do you think that not having a convention on crimes against humanity feeds this perception? Because we have the Genocide Convention, but we don't have a convention on crimes against humanity. Hopefully someday we will. But to what extent do you think having one would actually combat this perception that this is somehow not as important?
Yeah, and maybe Sean wants to speak to that too, or somebody else. I mean, one of my biggest frustrations is the genocide label. Victims really want what happened to them labeled as a genocide. Because then they get that international regime and it has that significance rhetorically. And so then you'll hear, oh, but that's only a crime against humanity, when actually the original category is crimes against humanity. And so really trying to combat that. The other thing is, because we had the Genocide Convention and No Crimes Against Humanity Treaty, is it gave states that sort of fig leaf. You don't have to deal with atrocities if you don't have a treaty on it, right? And it's not genocide, because that's the only one you have. Of course, it's almost never genocide, because genocide requires the specific intent to destroy a particular group, and it's limited to those 4 groups. So the absence of a Crimes Against Humanity Convention has hurt us enormously, actually. Only 1% of the cases at the Yugoslavia and the Rwanda Tribunal, this is the other thing that's wonderful about the ILC project, were Crimes Against Humanity only cases. Why is that? Because they were all crimes committed essentially during wartime for the most part. That is not true at the ICC, because the ICC operates in peacetime. So if you care about prevention, crimes against humanity is a huge part of your caseload, because crimes against humanity can happen before the onslaught of war. And Syria is a great example, where you had essentially human rights abuses that slid into and sort of an atrocity cascade, right? They slide into widespread or systematic destruction of the civilian population that then slides into all-out war. And so what's wonderful about the ILC project is it picks up this idea that crimes against humanity can be a peacetime crime. Genocide can too, it's just genocide almost never happens, right?
Well, I could address some of that too. I wrote an article in case International Law Journal called The Tiered Approach to International Crimes. And I ran very much into that when I was in Sierra Leone. I was asked but was there genocide? This is Security Council. But was there genocide? It's like, no, there wasn't. You could almost see the look in their eyes going, well, this isn't that serious. I don't think they quite said that, but the implication was there. And it struck me as I was prosecuting all of the war crimes and crimes against humanity, that I didn't have the G word. And therefore, it was a political problem for us to represent the court as what it was. It was almost had a diminished capacity because we weren't prosecuting genocide. So I explore that in this article called, not plugging the article, but I have actually realistically saw that happen, because diplomats and politicians do look at it. There's genocide, there's crimes against humanity, and then there's war crimes. That's wrong, because if you approach this as this is for and about the victims of international crimes, then the victim doesn't care whether his family was wiped out because it was a genocide or a war crime. They're just as dead. So if you look at it from that approach, it becomes a little bit easier, and that's how I talk to diplomats and politicians. That's how I approached it, as opposed to looking at it in a tiered way. So I appreciate your comment, because I think it's kind of an understated, kind of an undercurrent throughout all of this, is just that. The diplomats and politicians are looking at it almost tiered-wise. I think that's going away, but initially that was a big issue.
Sean, do you want to expand on that?
So I do think that it's possible that the term genocide resonates in some sense more than crimes against humanity. Everybody knows what homicide is. Genocide, killing of people, it's very evocative in its own way. But I tend to agree with what others have said, that I think a lot does have to do with the fact that we have a Convention on Genocide that obligates states to act when a genocide is occurring, which of course makes them back off from declaring that it's genocide, but still that shows you the traction of it. It obligates states to adopt national laws or to have the convention operate automatically. Does the U.S. have a Genocide Convention Implementation Act? Yes. Does the United States have a Crimes Against Humanity statute? No. Right? So when crimes against humanity comes up, it doesn't sort of automatically have some potential blowback in terms of U.S. law in the way that genocide would, or for that matter, torture, because we have a torture convention implementation statute. I think maybe it was Layla or someone earlier said, why do we have a Bosnia v. Serbia genocide case? It's because we have a treaty on it. It would have been a crimes against humanity case, and it might have had a very different kind of outcome if we'd had a treaty of that kind. So I do think that there's something to the idea of having a treaty. And if I can just briefly respond to one of Christian's comments, the commission in the first draft of the articles did not knock out the gender definition precisely for the reasons that Christian was referring to, that it seemed like there was a stasis coming out of 1998. As we looked at the developments over the past 20 years, and as we looked at reactions, not just governments from, say, Europe and North America or whatever, but a broader array, it seemed to us that there has been a change. The question will be whether that's the right calculation or not. But basically, as I think I said before, 95%, 96%, whatever, is verbatim the Rome Statute. And because the Commission has offered this up, I think the starting point of any negotiation is going to be that draft. It's not going to be so easy to move off of it, I personally would predict. And it's going to have a certain amount of credibility because of the background story of how we got there. So I'm hoping it is a Christmas present at the end of the day.
All right. Well, unfortunately, we have run out of time. Please join me in thanking our terrific panelists.